All right, guys, this courtroom session kicks off with what seems like a routine discussion, but it quickly turns interesting. The defense tries to bring up issues about a towed vehicle, possibly hoping to shift focus. But the judge shuts that down fast, making it clear that none of that matters here. The real issue is simple: no proof of insurance, and the court isn't going to entertain distractions.
Your Honor, I do know I did speak with Mr. Whitford, who's here again this morning, or this afternoon. I did speak to him before docket this afternoon. I think we're kind of in a position where I would imagine it's going to be set for trial. So I don't know if you want to call him. I did ask him if he wanted to retain counsel. He indicated he doesn't need counsel. So
okay, I think it's no insurance and some traffic things. Is that right?
Yes, Your Honor. The question was when we were back in court. You want me to wait? Are we on?
Yeah, let me go ahead and call it. We're on the record on People's State Call versus Eric Whitford. Mr. Whitford, you go to the lectern there. 25T588, appearances starting with the prosecution.
Darren Betkowski for the people.
All right, and Mr. Whitford appears without an attorney. Go ahead with respect to your understanding of the status of the case, Mr. Betkowski.
One of the major points of contention is what happened to Mr. Whitford's vehicle. There was some confusion by the court as to why his car would have been towed. I did reach out to the police department on that. What I've received back, Your Honor, was essentially an abandoned vehicle cover sheet. They said it was treated as an abandoned vehicle. Reasons for tow. The best they have in there is just a check mark on the impound lot.
Okay.
But from my understanding and reading this, it's pursuant to CRS 42-4, 1801, 1804, notice of towing from a public place.
Okay. Mr. Whitford, all of that has nothing to do with the charge against you in this case.
At this point, the defendant shifts strategy and starts questioning the very foundation of the court itself. He asks whether this is a civil or criminal matter and even brings up constitutional authority. It's a classic attempt to challenge jurisdiction, but the judge stays direct and grounded, steering the conversation back to one thing: plead guilty or go to trial.
And none of that's admissible at trial, but if you want to plead not guilty, the failure to have insurance, then we can set it for trial.
Actually, I have some procedural questions real quick.
All right.
Is this court subject to the Colorado Rules of Civil Procedure?
No, because this is a criminal court. The rules of civil procedure apply to civil cases.
Am I not being charged with civil offenses?
No, you're being charged with criminal offenses.
Oh, so all three of these are...
the insurance is a criminal offense. The other two are, you're correct, are by statute and by rule considered civil issues.
Then wouldn't
the rules of civil procedure don't apply to them.
It doesn't apply to them?
No.
Okay, so is this court subject to the rules of the Constitution and the Bill of Rights?
Now the tension builds as the defendant refuses a plea deal and confidently chooses to represent himself. The judge sets a trial date and even gives a subtle warning about how difficult self-representation can be. But the defendant pushes back, claiming he has already won trials on his own. The judge's reaction says it all. He's heard this before, and it rarely ends well.
Yes.
Is this a common law court or a admiralty law jurisdiction court?
It's not an admiralty court. We have nothing to do with maritime issues. Do you want to enter a not guilty plea and set the case for trial, or do you want to see if you can resolve the case by plea agreement with the DA? Those are the only two things I need to find out from you.
I haven't been offered any type of plea agreement yet.
Your Honor, we would be happy just to have him plead to the no proof of insurance and be done with it.
All right. You want to print out a proposed plea, and then Mr. Whitford, I'm going to have you look at that. It'll set forth what the fine for that is. If you decide you don't want to accept that plea, we can enter a not guilty plea on your behalf and set the case for trial. And
I'd rather just enter the not guilty plea.
All right. We'll get the case set for trial. Speedy trial deadline will be 6 months from today. Give me a second. We'll get your trial date. It's going to be in it'll be in April, given the number of cases we have set. Do you intend to hire an attorney?
No, I'm not a meddling volunteer or a ward of the court.
All right. You're going to try and do the jury trial on your own?
Absolutely.
Okay. Let's try.
Just when things seem under control, a second defendant steps in and immediately disrupts the flow. Instead of answering basic questions, he starts using special appearance language to challenge jurisdiction. The judge tries to get a simple yes or no, but the defendant avoids it entirely, creating a tense and slightly chaotic moment in the courtroom.
April 29th, this should be a case that we can finish in one day. So April 29th at 8:30 will be the jury trial date. The pretrial readiness conference for that will be on Friday, April the 17th at 10:30. That pretrial readiness conference, Mr. Whitford, we set more than one case for trial every week just because of the number of cases we set for trial. The pretrial readiness conference is to determine whether your case or another one is going to go to trial. What determines that is the case that is closest to its speedy trial date being up goes. I'm fine with you appearing virtually in that April 10th date. I'm not going to set a motions hearing date. I do want to set, well, so it wouldn't hurt for you to observe a trial. Cases are live streamed, and there's live stream instructions on the website if you want to just go on the live stream and watch us do a jury trial so you can see how a jury is selected and how a trial proceeds. You're certainly welcome to do that.
I've been through several trials and won a few of them by myself so far.
Okay, you're not the first person who's told me that. The last person that told me that broke down in tears when we started the trial, but I'm not saying that'll be you. But you're not the first person I've heard that from. You've done a jury trial before?
Yes, I have.
Okay. All right. Fair enough. If you have a seat, I'll have my staff get you notice with the dates on it so you don't have to try and remember.
I do have one other question. The entity known as the People of the State of Colorado, is that a creation of the state?
I would say it's a creation by the legislature. So yes, I guess you could call it a creation of the state.
Okay, thank you.
All right, just have a seat. My staff will call you when you have that notice.
And Mr. Anthony Meyer.
This is where everything escalates. The defendant continues firing off complex legal-sounding arguments, demanding proof, dismissals, and questioning the legitimacy of the case. But the judge doesn't entertain any of it. One by one, every motion is denied, and the case is firmly set for trial. Despite all the resistance, the court remains in full control of the situation. Like the video, subscribe to the channel, and we'll see you in the next video.
Please come up to the podium so you can be on a microphone. Otherwise, your statements won't be recognized.
I'm Anthony Meyer. And appear by special appearance to challenge jurisdiction.
Wait until you're at a microphone, sir, so you're being recorded, please.
Okay, very well.
There at the podium.
From special appearance only, not as the named entity.
Come on up to the microphone, please. Let me ask, are you Anthony Meyer? Yes or no?
I am Anthony Meyer and appear by special appearance to challenge jurisdiction and confirm administrative default to avoid joinder. And I am approaching under special appearance and not as the named entity.
This is the case of the People versus Anthony Meyer. Are you Anthony Meyer? Yes or no? And that will determine whether or not there's a failure to appear today.
I am, Your Honor, I stated that I am Anthony Meyer.
Okay.
Here by special appearance.
Mr. Meyer, you've already made your statement. You've made your statement.
You're interrupting me, please.
You've already made your statement this morning. Now, we need to reset the case for trial. You've already said that. Right?
I'm only here to settle the accounting.
So you have two options. You can go to trial, or you can plead guilty or no contest to the charge of no insurance. You want to have the case reset for trial? Yes or no?
I'm here in honor to settle the matter.
Then let's settle it. If you want to know proof of insurance, you can take that. If you want to go to trial, you can do that.
Can you have the DA read the charges into the record?
You're charged with no proof of insurance. You can plead guilty, no contest, or proceed to trial again.
I don't see any proof of the charging instrument. Or
you were issued a summons and complaint that's adequate to inform you of the charges. contest or stand by the not guilty plea that was entered by the court on your behalf, and we will reset the case for trial. How would you like to proceed?
Before